into the second half, premiership quarter. We'll push on, I suppose, to costs orders and the differences between a number of the orders. It's on page 5 of the handout. And I suppose I'll touch on some of the most common questions or, I suppose, queries in terms of obtaining and the wording of orders. Costs reserved versus costs in the cause, the very, very basic way of saying it is if you're very, very confident you're going to win, costs in the cause is outstanding. If you're not, costs in the cause is problematic because costs follow the event and obviously it's determined by the outcome either of that application or the final hearing. Costs reserved, I suppose, is a much more open costs order. And what it does do is give discretion to the cost consultant to argue at the taxation that those costs should fall either way. That can be important because if you actually lost on the end proceeding, it does give the opportunity for an argument that costs of that particular application ought to flow to the defendant, for example, if the defendant was ultimately unsuccessful. It's a discrete costs order with respect to the costs that were incurred relating to that specific application. So it may be something that the defendant was overall successful on, that they'd said to the plaintiff that we're going to adopt this course of action. If you don't agree with us, we'll seek costs, but that either the court didn't deal with the actual costs of that application at the time, or the parties at that time may have consented to a costs reserved costs order. So I suppose the important thing with costs reserved is that it says that somebody, in most instances, will be entitled to costs, but the question as to who that party is yet to be determined, and that's something that can be argued before a costs judge or cost registrar on taxation. The no order as to costs and silent costs orders, technically speaking, the legal position is that a order that's silent as to costs flows to the party that's ultimately successful, but there is room for argument that if it's silent as to costs, it's the equivalent of no order as to costs. That's a dangerous proposition. It's not one that I particularly agree with, but I have seen it argued before and I've seen it upheld in the costs court. There were very particular bases for it being upheld in that instance, but in order to, I suppose, obviate the possibility of that happening, at the very least you should be entering an order for costs reserved. And if you look at the very basic example of that, which might be extending the timetable for a proceedings, there's ordinarily a letter to the other side proposing that you do that, proposed consent orders, potentially a letter back with amended consent orders, getting instructions on those amended consent orders, executing them, filing them with the court, sending a letter out to the court. It can be in the hundreds of dollars, maybe up to the thousands of dollars for that very basic activity in a lot of senses. If you don't address the issue of costs in those costs orders, you do leave yourself exposed. So at the very least, I'd be saying to make sure that on every minute of consent orders or everywhere where costs ought to be addressed, that the bare minimum, obviously the best outcome is that you obtain an order for costs in your favour, but at the bare minimum at least give the opportunity for the cost debate to be had at a later time. Costs of the day versus costs of the application. Costs of the day is essentially that. It's costs of an appearance on the day, it's costs of counsel appearing on the day. You run the risk of losing your summons to get there, your affidavit to get there, your letter to the other side in between, your taking of instructions in between the time the summons was filed and the actual hearing date. Costs of the application is much more global order in terms of entitling the cost consultant to recover costs which were costs of essentially and incidental to that application. So for that reason, it's a much more beneficial order to obtain. The one thing that is in there that isn't dot pointed, but it is referred to in the blurb, is the rule with respect to amended pleadings. If you amend a pleading, the automatic entitlement to the other side is to recover the costs of and incidental to that pleading, to the amendment. Likewise, if the other side amends a pleading, you're entitled to your costs of and incidental to that amendment. The difficulty comes with the grey approach, I suppose, to the term costs of and incidental to. There's an argument that of and incidental to is a prospective term, so essentially it entitles you to your costs after the amended document comes in. So that is answering potentially all the additions that are included in that amended document. There have been arguments mounted that it doesn't include costs thrown away because it is a prospective clause. Costs thrown away might, if you're the defendant, for instance, and the plaintiffs relied on 10 grounds in their statement of claim and a month before the trial they remove 7 of those grounds and rely on 3 of them, and you've spent the last year getting expert reports, getting evidence, attending on witnesses with respect to the other 7 grounds in their statement of claim. If costs of an incidental to is a prospective clause, all of that work is lost and not included in the order. So it's always beneficial to obtain an order for costs of an incidental to the amendment and costs thrown away by reason of the amendment. That way the costs that you've had thrown away are covered, and the costs that you're likely to incur by any potential change to any of the pleadings are covered as well. So your costs of the amendment in their entirety are protected. And that's, I suppose, a particularly worrying area, because most of the time costs thrown away is the larger area of costs with respect to amended pleadings. I will push on now to the new county court scale. And I think that the tagline that was given to it was that it's more than a facelift, and it is. The county court scale has been radically changed with respect to costs that are incurred after the 1st of September 2011. In starting off talking about that, I'll say that I'm not aware of a bill being taxed yet including costs from that period. Ordinarily your costs are anywhere up to 24 months, 36 months incurred previously to the time that you draw the bill of costs. So we're yet to really be given a very clear outline as to how the scale is actually going to be interpreted at a practical level. But just having a look at the scale, I suppose superficially, the main area that's been changed is you no longer have your scales A, B, C and D in the county court. It's much more aligned to the Supreme Court scale in that you have, in most instances, lump sum amounts that are allowed for a specific activity. So for drawing a specific document, for instructions, you don't get the gradual move up the scale from scales A to D. I suppose the primary feature or something that I think is very positive about the new scale from a professional cost perspective is that it's probably now the scale that reflects the commercial reality of running litigation most properly. It includes, I did teeter with the idea of attaching the scale to the presentation, but I didn't want the talk to become solely about the county court scale, which is what I feared would happen if we did that. But it does include an item, for instance, engrossing or approval of documents. So, for instance, if you've received a document back from counsel, the ruling was always that, well, you don't get an allowance for receiving a document or perusing a document that your own counsel's drawn on a party-party basis. There is now a specific allowance for that under the county court scale. There is a much, I suppose, more detailed breakdown of the letters that are allowed. So you have a short letter, you have a message, which is 20 words or less, then a short letter, which is 1 folio less, so 100 words or less, and any other letter which can be claimed on a drawing and engrossing basis. So if you've written a particularly detailed letter, it might be a letter of advice or reporting on the outcome of a day in court. Under the old scale, unless you could mount a particularly strong argument that drawing and engrossing ought to be applied, you were really limited to the letter allowance, which was $40 odd, $41 I think, for a necessary letter in the county court. Now there's the option there for costs to be claimed on a drawing and engrossing basis where a particular element of skill has gone into the production of that letter. And we always see letters that are 3, 4, 5 pages long, and they're really the primary letters that are provided to the client when you send your disclosure statements to the client at the start in your costs agreement. And in terms of the type of advice you say that you're going to provide to the client, the content of that is formed in those letters. To only allow $41 for that letter seemed grossly unjust, and I think the scale now properly reflects the time that it takes to produce that sort of a document. There's also an allowance for receiving and filing, which is the approach currently in the federal court. So essentially for every letter that comes in that you receive, you get an $11 allowance. There's an allowance for scanning, examination and review and consideration, so breaking down into much more depth all of the documents that a solicitor looks at. It's been said that formerly the instructions for brief item didn't include things such as research. It didn't include it didn't allow for looking at a document more than once. So your perusal rate of $5 per folio was perusing a document in its entirety once throughout the course of the proceeding. So if you looked at it when it came in and 2 years later you went to court, and that document became more and more relevant as the litigation proceeded, The fact that you might have gone back and looked at that document 20 times within the course of that 2 years wasn't accounted for. You got your $5 per 100 words and that was it. Under the new scale for reviewing, examining and scanning, there is a general allowance there for a solicitor to go back and review a document for the purpose of providing advice, for the purpose of addressing that document specifically in correspondence to the other side or referring to it in a pleading. So it much more properly reflects the actual approach that's taken in terms of when you go back to your office and do your day-to-day job. That being said, there's also an allowance for delegation and supervision. The practice in most law firms is that a junior works on a file in combination with somebody who is more senior, and the junior's rate on a commercial basis is less on the basis that it may take them longer to do it, on the basis that they may not get it right at the first instance, they need to take advice on it and go back and amend that document. The scale now allows for, I suppose, the actual commercial setup where a principal will sit above a junior, review work, and there's an allowance for the time that's spent doing that. There's also an allowance for research. Yes, I'll just, if we can just grab the microphone.
Thanks. Just on that last one, what type of evidence do you think we need on the file? Things like delegation and supervision, you might not know yet, but...
No, it was going to be something I was about to touch on. It makes time annotations on the file notes absolutely pivotal. One of the things I suppose I was about to touch on, and one of the questions we often get with respect to evidence in your work as a whole is why can't we rely on time records that we punch into the electronic system each day? The reason's essentially twofold. One, the court is of the opinion that a contemporaneous file note is better proof of the work that's done than, I suppose, a time ledger that could have been completed at the end of the day after the day's work's been done. The second reason is that a lot of the time entry systems don't allow for a significant amount of detail to be input in the narrative, or they have preset codes of how the particular time spent is detailed. The difficulty with that is that, for instance, if you've had a telephone conversation for 2 hours, we can prove that the telephone attendance happened on the basis of the time ledger because there's a record for it there, although it may not be contemporaneous. The difficulty is proving that the time attendance was necessary and proper, or that it was reasonable. Was it necessary and proper for the attendance to take 2 hours? Now, if your time ledger says it took 2 hours, but your file note has 2 lines of notes taken with respect to what was actually discussed, it's virtually impossible for a cost consultant to sit there and argue that it was necessary and proper to be on the phone to the client for 2 hours. You don't know what else was discussed outside what is written on the file note. It may have been an hour and a half talking about the fact that the client hasn't paid fees or negotiating the terms on which they're going to pay the fees, which wouldn't be allowed on a party-party basis, for instance. So the court can't assume that because your time ledger says 2 hours, that it was necessary and proper or reasonable for it to take that amount of time. We do have another question just behind you there. I'll just continue before we get to that. So with respect to, I suppose, properly documenting that delegation and supervision task specifically, I suppose it's a habit of getting into the practice of the principal taking a file note of what's discussed in that conference and treating it as a conference, and then the principal and the junior making an account of the time that's spent. The junior's time is not going to be allowed, but the supervision of the junior's role within the firm, if you can, for instance, say that you had a conference with the junior for 15 minutes, 20 minutes, what was discussed, and it may not be that you're allowed all of that conference on a party-party basis. If the junior's made a very clear mistake, the court will more than likely deem it's not something that the client should be liable to pay for. But if it's a task that ordinarily is delegated to the junior, that the juniors perform that task as they reasonably would be expected to, and that the supervisor or principal has reasonably supervised the performance of that task, it ought to be allowed under that scale item. So the way I suppose to ensure that you get that is to make sure that there's file notes evidence in the conference that goes to the specific activity. The question up the back.
Yeah, thanks, Michael. While you're talking about file notes, I hear some pretty scary things that come out of the cost court. One, for example...
You need to narrow that down a little bit more.
Yes. One, for example, I hear that if you review a letter, you have to have a file note to say that you reviewed the letter to get the costs for reviewing that letter. Is that right?
not in my experience. If you review a letter, it's assumed that you've perused that letter and it should be allowed at the perusal rate. I'm not aware of anyone having to carry the burden of making a file note saying that they've reviewed a letter and recording the amount of time that it took. If it's a solicitor-client basis, there may be an argument on the amount of time that it ought to have taken, in which case a file note would evidence the amount of time that's taken and might speak to justify it, but on a party-party basis, it's assumed it was perused.
Yeah, so just a timesheet will suffice. A solicitor has looked at the letter, reviewed it, and that would be sufficient evidence for the cost court.
Well, yeah, if that's all it was, if it was reviewing the letter, if your time entry says reviewing the letter, I'm not sure there's that much more detail that you can provide in that instance. I mean, we're talking specifically about a solicitor-client basis here, because I'm not aware of any instance where on a party-party basis you have to record your time for reviewing letters. But say, for instance, it's a 2-page letter and the solicitor's put down an hour or an hour and a half for reviewing it. In that instance, you run into the difficulty on a solicitor-client, so the reasonable test kicks in. Was it reasonable to look at that 2-page letter for an hour and a half? Now, on the face of it, you're probably not going to get it allowed, but if you had to look at that letter for an hour and a half and consider a specific number of issues raised by that letter, unless that's detailed in the note, you're probably going to have difficulty getting your hour and a half. So in terms of the feedback that's come back that you need to make a note of reviewing the letter, I'd say basically reviewing a letter, no. If there's extraordinary circumstances or it's taken beyond what might be termed a reasonable time to look at the letter, the only way that that extra portion of time could be justified would be by a file note saying why.
Going back a moment to...
If we can just... Sorry. That's all right.
Michael, going back a moment to the new scale fee for filing letters and so on as they come of $11, I think you mentioned.
Yes.
Does that apply to printing emails from the other side, and does that apply if they send you a letter by post and a fax for the same letter?
It's item 32 for your reference, but it says any incoming document, including correspondence, whether by electronic means or otherwise, including first page for file, copies of additional pages received electronically, be charged pursuant to item 29, which is the copy rate. So if you get an email that comes in and you print it out, that's included in that $11 charge, and you're entitled to recover it. In the instance where the letter's received, again, by post, it's an interesting one. I haven't, as I say, it hasn't been dealt with yet, but I would say you have to claim it. Technically, under the scale, it is receiving and filing the document. Now, if you don't receive the document and you don't review the letter again to make sure it's the letter that you've already reviewed, you're potentially negligent for not looking at that letter to ensure that it's something that's already been covered off. Under the scale allowance and the wording of it, any incoming document, including correspondence, I suppose the argument would be that it's potentially a duplication of the costs recovered, but I don't see any way around that in terms of the solicitor being obliged to ensure that they look at the correspondence that comes to their attention. So if I get a bill and it's in it, I'll be claiming it. I'll let you know how we go. No, nothing else. Also, there's an allowance for research. The instructions for brief portion of bills, ordinarily you didn't include reading case law, and there is very dangerously a ruling that a practising solicitor is assumed to have knowledge of every reported decision ever. So it'll be hitting up Osley over the next few weeks, I'd imagine. But if it's an unreported judgment, it's something that you can claim and recover in the instructions for brief portion of the bill, but the ruling has generally been that if it's a reported judgment, you have great difficulty in recovering it. So under this new research provision in the county court scale of costs, there is an allowance for time spent researching. There's also an allowance for collation, pagination and indexing of documents with respect to briefs to counsel, court books, appeal books, etc., and redaction of documents where there's issues of privilege. So it goes above and beyond what I can see in any other scale in terms of properly specifying the work that a solicitor does on a daily basis. The manner in which all of those items are allowed is covered by item 41, which goes to attendances. You've got a per quarter hour attendance, which requires legal skill or knowledge, of $52. You've then got a 75% allowance of that at $39 for a clerk who performs an activity that someone with the legal skill or knowledge could have performed. So essentially it's someone without the potentially without the qualification, but performing an activity that a solicitor might otherwise perform. And then you have your 50% allowance for what is your basic clerical attendance at $26. So the collation, pagination, redaction, research, delegation, supervision are covered off by those set rates as applied throughout the course of the proceeding. So, as I said, in terms of recovery, I think the county court scale is in much better shape on professional fees. And for the reasons I'm about to touch on, I think it is in a hell of a lot better shape with respect to fees for counsel. As I touched on before, the fees for counsel under the county court scale previously were very, very miserly. And in the absence of certification, there wasn't much room to move for a registrar, or there's no room to move for a registrar to allow it above those ranges. Item 42 in the new scale goes through your fees to counsel. It breaks down a range for hourly and daily rates for junior and senior counsel to be allowed. And to give you a flavour for it, appearances on trial or appeal including up to 4 hours preparation, junior counsel $1,500 to $4,200, senior counsel $3,550 to $6,600. So that's the range within which costs can be allowed within the costs court in the absence of a specific order by the court on the substantive proceeding fixing costs in a certain amount. Now, if you fear that the cost court's going to take a dim view of the fees that have been charged by counsel and you want to shore that position away, there is still the option to have counsel's fees certified, particularly where you need to get counsel's fees certified above that range. So if you've briefed a junior on a particularly complex matter and they've marked a fee above that range and you want to ensure that the cost court's aware of the fact that you could have briefed senior counsel to appear on this matter, the matter was significantly complex and complex enough for senior counsel to have been involved, and therefore it's necessary and proper or reasonable for junior to have rendered fees in the manner in which they have. There is still the option there for the person making the final order to make an order also with respect to the certification of costs. Where two or more counsel are engaged and you want to shore up the position with respect to their fees, you also need to obtain certification. Certification of the second counsel's costs. The one thing that has occurred now is that ordinarily your orders for certification included an order for certification of preparation of the court book on the scale rate and then a number of copies on the commercial rate. The new scale allows for 21 cents per page, so it's a dramatic reduction from the other scales. I think we're still operating on $2.10 in the Supreme Court at the moment. But 21 cents per page for copying across the board. So you'll see a fall away, I suppose, in the certification of fees with respect to preparations of court books. I'll move on into some of the other areas, and what I did touch on at the start there was that trial fee includes up to 4 hours preparation. I did a talk at another list 6 weeks ago and was afraid there was going to be a riot in the room when I mentioned that 10 hours of counsel's preparation is deemed to be included in the first day's brief fee on a party-party basis. The number of questions that were fired at me on that day, I think totalled the questions from all of the other talks altogether. It's not something that most counsel, well, it's certainly not the basis on which most counsel charge, and it certainly isn't something, I suppose, that's known across the board. The ruling really is it's 6 to 10 hours preparation is included in the first brief fee. It seems to have been adopted to be 10 hours, which is unfortunate. But the county court scale now specifically says it includes the first 4 hours. So presumably above and beyond those 4 hours, provided it's reasonable, you can claim your preparation at the hourly rate allowed for in the scale, which for juniors $150 to $420 and senior $360 to $660. I should say that all of these are exclusive of GST as well. So there's I won't go through them all, but there's an allowance for conferences, there's an allowance for views, drawing or settling documents, opinions and advices, and then a generic not otherwise provided for. The position, therefore, is that the cost court can allow counsel's fees within those ranges that I've just discussed. Now, the ranges are broad, so $1,500 to $4,200 for junior counsel for a day. There is still very much a need to lock away counsel's fees where you can in the county court. It's a hell of a lot better than the old $240 for drawing of a document, although if you look at it, for drawing or settling a document, it's $150 to $420 for junior counsel. So there's the potential that it can drop from $240 to $150 for drawing a statement of claim in the worst instance. That's on an hourly basis. So I would still say that even though these ranges have come in, don't throw away the need to obtain certification and to advise counsel to seek certification of their fees. With respect to certification, it can be of anything. And most judges within the county court would have had an application for certification made to them. Most of them would have made them. They're not something that is unique. And it can be for conferences, it can be for drawing documents, it can be for appearance in mediation, appearance on the day of the hearing. Basically, you should be turning up on the day that cost orders are going to be made with a schedule of everything that's counsel's charged and asking for certification of counsel's fees. It's unlikely you're going to get them on the basis on which counsel's charged you, but the basis on which you are going to be awarded costs is almost always going to be higher than what you're going to be allowed under the scale or now at the discretion of the registrars in the cost court. So I suppose the thing to take away with respect to counsel's fees is if certification isn't obtained, we're in a better position to start with, but if you can still obtain certification, do so. I'll push on now, I suppose, to finish up with tips just for the last 7 or 8 minutes on maximising counsel's costs, maximising recovery of costs. From a professional perspective, the main one I always give is with respect to clerical attendances. The clerical attendance rate in the Supreme Court's $40, the skilled attendance rate's $67. If you're in the habit of having paralegals, PAs, clerks, do an enormous amount of work each day, if they're doing 3 or 4 tasks on a proceeding each day and the proceeding runs for 4 years, it mounts up over time. It becomes tens of thousands of dollars. If their work isn't properly recorded within the file, it's impossible for us to claim it and you're not going to see it at taxation. Particularly where you apply the load into the work that they've done in that instructions for brief portion, you can have the $40 15-minute attendance going to somewhere akin to $80 for each 15 minutes. If they're doing 3 or 4 things a day, it's $300 or $400 a day, or $250 to $300 a day, and they're doing that over the course of years, it's going to get to tens of thousands of dollars. So everything that your clerks, paralegals, PAs do ought to find form on the file and ought to be, I suppose, sufficiently detailed to enable it to be included in the bill of costs. The other tip I would give would be with respect to drafts, to keep them. There's nothing more troubling than getting an email where the attachments haven't been printed out and it's clear there's been 10 or 11 goes at getting something in its correct form, but none of those are found on the file anywhere. The reason why drafts are important is twofold. On professional fees, you can get the amendments that you make to a document recovered, so you don't just have to take that first hit of it. Each time you go back and amend it, you might get new information. There might be something coming in from the defendant's documents that needs to be addressed. Each time you go back and amend it, provided it's reasonable and necessary and proper, coming back to those tests, you'll get it on a per folio basis. The other reason it's important is in terms of justifying counsel's fees. If counsel spent 10 days preparing an affidavit and the affidavit's 30 pages long, the starting point really for the cost court is to sit there and say, well, why on earth was counsel spending 10 days preparing a 30-page document? Now, if the case has been that it's gone back and forth between the solicitor, that there's been conferences with witnesses throughout the course of preparing that document, documents have been obtained from ASIC, whatever it might be, that means that that document has to be drawn and then added to again and again, and that's reasonable for counsel to do that for a day at a time over the course of a month for 10 days. The fact that the drafts are actually on the file means we can point to them and say that on this day where counsel spent a day amending the document, this was the format that he got it in to start with, this was the material that came in which needed to be incorporated in the document, this is what he sent back to the solicitor the next day. Otherwise, you're standing there point blank with the end document and 10 days of counsel's fees for $30,000 to $50,000. It's not a great starting point to be starting from. Moving on to counsel's fees, the instructions for brief portion of the bill is probably the area that's most liable to attack because it's dealt with globally. You don't sit there and go through every attendance or every letter normally on a taxation for instructions for brief. So the fact that you're dealing with, in some instances, $50,000 to $200,000 for instructions for brief and submissions are made and that figure's dealt with globally, you are going to lose $5,000, $10,000, $15,000 potentially off your instructions for brief portion, depending on the determination that's made by the registrar. The other large, I suppose, chunk area where costs are lost is with respect to counsel's fees. Page 8 goes into some of the difficulties and why that is. The preparation time I've touched on, and I don't think needs to be touched on again. The narratives that are given on invoices and the memorandums that are provided by counsel can sometimes cause difficulty. And I'm speaking specifically, I suppose, of the memorandums where you might get an invoice for 2 months' work where it says preparation, reading papers, conferring with instructor and witnesses, $80,000. Now, if that's the only detail that's provided for that claim for costs, it's incredibly difficult to justify that it was necessary and proper or reasonable based on the very limited detail that's provided in counsel's memorandum or invoice. Yes, we can refer to the solicitor's notes to advise as to what counsel was actually doing, but it's much more beneficial to get an adequate breakdown from counsel as to what they were doing each day and each hour, preferably. The other reason why that's problematic is that if you obtain an interlocutory costs order and you receive a lump sum invoice, including the time that that interlocutory application was going on, if it's a very generic description of the work that was performed, it's impossible to break down for the court what costs were involved in the interlocutory application and what costs were the substantive proceeding overall. That can be important because if you get an interlocutory costs order and you want to enforce it straight away to put pressure on the other side or to force a settlement, if we can't incorporate counsel's fees in that bill of costs because the description's too generic and we can't determine how much of that costs went to the application, it makes obtaining an order on taxation that's sizeable very, very difficult. So I suppose it comes down to, from a solicitor's perspective, properly briefing counsel from the start, providing a breakdown of how you want counsel to account to the solicitor for their fees, what work you want counsel to do, ensuring you comply with the Legal Profession Act in terms of obtaining disclosure from counsel and forwarding that on to your own client. You'll find the disclosure provisions for solicitor under 3.4.9 and counsels under 3.4.10. The disclosure provisions for a solicitor are much more detailed than they are for counsel. So it's important that you comply with both of those in terms of the exposure on your own costs and potentially bearing the shortfall of counsel's costs. And then making sure that the invoices you get back are for work you've actually briefed counsel to perform. There's instances where counsel's been briefed to draw a statement of claim. Counsel's drawn that statement of claim, not unreasonably providing advice back with that statement of claim saying these are the issues involved, that the defendant's position is likely to be X, we need to chase up X, Y and Z in order to shore up our position. This is where the litigation's likely to take us. The difficulty is that if a specific request for that advice hasn't been made and that advice is included in the invoice, you don't recover it on a party-party basis. So it's a matter of briefing counsel to do something, knowing what they're going to charge, ensuring that they do that work, and then checking the invoice to make sure it's what you briefed them to do and that the amounts are within the cost agreement that you've made with counsel. There's some tips there on page 8 for the way to go about doing that. I'll just run them through very quickly because I think we're in the last minute or so. A separate back sheet to be forwarded to counsel. It's archaic, but it's still the best way to recover costs if you can point to a back sheet that's been forwarded to counsel. In the absence of it, at least a paper trail. It's often not very useful to be sitting there drawing back sheets to counsel when you've got an injunction application that's going to be made the next day and you're worried about making sure that you get the cost for briefing counsel. But if we can show that counsel was sent an email to perform a specific activity, it comes down again to the detail in the email. What were they asked to do? What was the basis on which they were going to do it? How were they going to charge? If you've already briefed counsel at the start and you know how they're going to charge, we need a paper trail showing that he or she was asked to do that particular work. And ensuring the fee slip, again, marked by counsel, correlates. The other thing, and probably the thing I'll finish on, is that on a party-party basis, you're unlikely to recover items with respect to conferring with counsel where it's deemed to be general conversation about the case. So if you have a conversation with counsel, unless it takes the matter somewhere that it wasn't within the solicitor's realm to know that the matter was going to be taken, so counsel may have gone and addressed something that it wasn't reasonable for the solicitor to know and advise the solicitor of that. Counsel might have conversation with counsel on the other side and advise the solicitor of that. That sort of activity you will be fine on. On conversations and emails back and forth where you're generally discussing what you're going to do throughout the proceeding, on a party-and-party basis, you generally don't recover it. So in terms of conferences with counsel, it needs to be a conference, I suppose, that takes the matter somewhere to recover it on a party-party basis. And that too is sometimes a bit of a downfall on party-party costs, because invariably counsel will charge for the communications in that time, unless you can prove that it wasn't or it didn't form part of his or her general brief. It will be included in that all-encompassing sort of brief fee preparation item and go to the hours that are allowed in those first 10 hours that I spoke of. I think everyone's conscious of getting off to work, so thanks very much for your attention throughout. If there's no... Oh, there's a question up the back.
Thank you. Just a couple of things. What would you estimate to be the increase, percentage increase under the new county court scale in recoverable costs?
Across the board?
Yeah.
Oof, $10 million question. I suppose it depends on how it's interpreted. I mean, all those research supervision criteria that I spoke of before, if they're allowed liberally and they're allowed as they appear to, or to be read by reading the scale, well then the increase could be somewhere across the board of, I'm speaking very loosely, but 20 to 30%. If it's basically a scale that's going to be interpreted in the same manner as which the old scale has, well, the increase won't be that high. But certainly from the wording of it, it seems to be a very direct approach to include items that weren't ordinarily included before the scale came in.
And also on percentages, in your experience on taxations, how much do you get your bills reduced by on a party-party and solicitor-client basis?
Reduced by?
Yeah.
So if we're objecting on party-party, but in county court?
Well, across the board, you can start with county court.
Across the board, look, you're probably looking at I'd say maybe 20% reduction on a bill of costs. I mean, you do get ones that are particularly well drawn, and if the file sufficiently evidences the bill and it's very detailed, well, you get less than 20%. I'd say probably 20% in terms of reductions. One thing I'll touch on with the solicitor-client basis, which is important to be aware of if you ever get involved in a solicitor-client dispute, is that if the client reduces your bill by more than 15% at the taxation, the firm's up for the costs of that taxation, in the absence of the firm having made an offer on which they're consequently successful on. It is consumer litigation, consumer legislation, and I suppose it does work against the firm from a cost perspective, because I would say that in 80% of the instances, the bill on a solicitor-client basis is reduced by more than 15%. So we always, well not always, most of the time advise the firms to make an offer of compromise to protect themselves from a cost perspective. But generally speaking, I'd say 20% on a party-party basis, probably 20 to 30 on a solicitor-client.
And you didn't touch on GST overall with all the costs, only on counsel's fees.
The county court scale, that's overall, so none of the items in the county court scale include GST.
Okay, do you know the reason for that?
Well, the reason that was given was that in a lot of instances, a company, there's a general rule that a company that's recovering costs that's entitled to a claim an input tax credit with respect to GST can't recover that GST from the other side. It's seen as double dipping. So if council charges 3,300, it'll be claimed in the bill of costs as $3,000, because they would have claimed $300 for paying council as an input tax credit. You can't then recover the $300 from the other side as well. The reason that was given for it not being included in the county court scale was exactly that most of the time it was coming off at taxation. There is dispute as to whether you can whack on GST at the end of a bill of costs, because it would appear that what's actually being provided for in the scale is a service. It's providing a service to do the research, it's providing a service to attend on the client. One would ordinarily think that if the concept of adequately compensating the client has to incorporate what they pay on a commercial basis, which does incorporate GST. But that being said, it's seen to have been inclusive in all of the other scales, and you don't get an extra allowance for GST. The county court scale at the start of it expressly says that it doesn't include GST, so I'm not sure the approach that they're going to take on that. Again, I'll be putting it in. If we get it, we do. If not, we don't. There's one.
Can I maybe call it to a close now? We've got some other people want to use the room. And Bill, can I get you to talk to Michael direct? I'd like to, on behalf of all of us, thank Michael Shiel for a very comprehensive and enlightening presentation this morning, which I'm sure has been helpful to everybody. Michael, on behalf of all of us, thank you very much.